Hello friends, and welcome to another WSIB Truth Matters with Joe Machado. I hope you had a nice and rested weekend, and I hope you're enjoying this beautiful Monday. Oh man, I'm hoping that it's going to stick around for a while. I've had enough of that rain and the cold, and make up your mind upstairs, man. Come on, give us some nice weather. Yeah, he doesn't listen to me most of the time. Anyway, as I had indicated in my last video, I hope you had a chance to have a look at it. If you hadn't, I strongly suggest that you do. But I'm going to talk to you today about appeals. And it's not necessarily the actual process involved with appeals, because it's kind of laid out. It's simple, it's easy, straightforward in terms of how you file, when you file, that kind of stuff. But more so, I'm going to talk about certain things that you may want to consider yourself as to whether or not you're ready for a hearing, whether it be at the WSIB's appeals branch or the Workplace Safety and Insurance Appeals Tribunal. And, over the past almost 30 years, I handled my fair share of appeals. And so did many of my paralegals. So I would say that I have a pretty good understanding and intimate knowledge of how it works and what can make the difference between success and failure. But I want to plant a seed right now for you before I move forward with this. And I want you to think about it as I'm going through this presentation, and then maybe even later on tonight or the next day or whatever. I want you to think about this because it's important. And that is, you know your case better than anybody. No one knows your case better. No one. Not your doctor, not your employer, not a WSIB's case manager, not a lawyer, not a paralegal, not your union rep. No one knows your case better than you do. And this is something I would always tell my clients. We, as representatives, which I was at one point, we have a set format, a game plan as to how we prepare and how we conduct an appeal and a hearing. And that's all good. Everyone develops their own style. And I think at the end of the day, we're all trying to work towards the same outcome, which is to get your benefits, what you deserve, what we believe you deserve within the law. So another thing that I want you to think about, and I always talk to my clients about this, is managing your expectations. Like I said in some previous videos, I'm not going to feed you any bullshit. I'm not going to tell you what I think you want to hear so I get more views and more shares. That's not me. If you actually could talk to any one of my clients over the years, they would tell you, I guarantee you, that I was always blunt, very straightforward. I didn't candy coat it, didn't dance around the issue or try to make it seem more than what it was. Because when you do that, you're setting the other person up for failure. And if you can't deliver on that, not only are they going to feel like you failed as a representative, but they're going to feel like they failed as well. And that's the worst possible thing. When you have an injury and you're trying to recover and you try and regain some control over your life, you don't need anybody else making you feel like you failed. So I'm always blunt, and I'm always going to tell you the truth and what you want and what I believe is right. You may take it or not, and that's okay. But I'm not going to feed you a line of bullshit. So when I tell you that you know your case better than anybody, you do. And can you handle that? Can you take all of that knowledge that you have and be effective to paint the picture, to paint your picture for another person who's listening to understand? Because all we do as representatives is we got a bunch of pastels, we got a paintbrush, And we're going to hear from you, and we're going to use the colors to paint what we think you're trying to say. So enough on that, but I'll get back to that as well, because that's important. Managing expectations and you knowing that you know more about your case than anybody else knows or will ever know, and trusting in that. So the appeals within the WSIB system, there's one appeals process. It's with the appeals branch. And you submit an appeal, an objection, or an intent to object. Then they send you an objection form with your file, yada, yada. You go down, you have a hearing, or it may be done written without an oral hearing, and there you go. Appeals officers are just like anybody else. They're human, just like you and I. The only thing about appeals officers that I've come to understand after having dealt with many of them is that they make mistakes too. They're a little more experienced than people in operations, your case managers and so on, but they do miss things too. They do. They make mistakes. So that's why there's also the ability to request a reconsideration of an appeals officer. The last week in my two-part video, I talked extensively about the whole reconsideration process and how effective a tool it is for anyone trying to deal with their entitlements. And I still believe in that. I think it's the most powerful tool you can use. And if you haven't watched those videos, you got to go back and watch them. They are the most powerful tools you can use to gain justice in your case. But again, as part of the reconsideration process under Section 121, appeals officers can have their decision reconsidered as well, okay, by their manager. So they get a first crack at it, and then it can go to their manager as well. And I've done that as well, trust me. A few of them weren't very happy with me, but you know what? I don't really give a shit. I wasn't there to make friends. I'm fortunate to have had plenty of friends. My job was for my clients, and I didn't compromise that in any way, shape, or form. So you have that whole form procedure, and then you go to a hearing, and blah blah blah. If you're well prepared yourself, you can effectively present your case. If you have a representative, he or she hopefully are well equipped, have the experience necessary to represent your case on your behalf while you're there. The same thing goes for the Workplace Safety and Insurance Appeals Tribunal. But here's the thing. There's no magic. I'm not a magician. I've handled and settled thousands of cases, but I can't perform any magic. All I do is present the information and make sure that it conforms with the law, that it's accepted within the law. And then persistent enough to make sure that I get the right person who actually is going to sit down and take a bona fide look at it and say, okay, yeah, I can see this. Because if I'm putting forth a bullshit strategy, it's not going to happen. It doesn't matter how well that person likes me, whether they think I'm really smart or good looking or can articulate myself well. No, it doesn't matter. If it's not within the law, it's not going to happen. So there's no magic there. And the same thing at appeals. It's the ability to effectively put forward the issues that matter in a concise manner by looking and highlighting the facts and making sure that's within the law. With respect to the Workplace Safety and Insurance Tribunal process, it's a little bit more extensive, a little bit more formal than with the WSIB. You file once you get a decision from an appeals officer, you file a notice of appeal form, and it must be done within 6 months of the date of the ARO decision, and then the process starts, and then at some point you have to follow your readiness form or confirmation of appeal form, and basically indicating that you're ready to go. And then they send you some information. They start sending you the case record that's going to be used. They request information from the WSIB in terms of policies that the tribunal will use and sections of the act that are applicable or sections that they think are applicable in the case. whether the WSIB does or not, but the tribunal requests that information because they are much more thorough and they're more adherent to the law, in my experience, than WSIB. And so it's a more formal process. And then you go before a hearing, and usually it's a 3-panel person. They're going to ask you questions, and if you have a representative, then with your representative, you're going to present your case, and hopefully that'll result in the outcome that you expect. So there you have it. It's very straightforward, well laid out. There's nothing I could do that would add to it or take away from it. So there's really no point in me spending time with that kind of formality, because that's not what you're watching this video for. You want to know if you're ready. You want to know what you need in order to be ready, so that you're confident, whether you're handling your case yourself, whether you have a representative, a lawyer or paralegal, or you have a union rep handling the case for you or helping you with it, or a family member. You need to be confident that you're ready to face that next step. Because if you're not ready, it's not going to work. And I'm not trying to scare the shit out of you. Don't get me wrong. But there are certain things that need to occur while you're at a hearing. And if you're not prepared for it, to deal with even the more less intrusive questioning, it will be problematic. And it's not like you have a do-over. So regardless of what anybody says, whether it's your lawyer, paralegal, or whomever, you need to know in here, you need to know that, yeah, I'm ready. I know my case well. I'm prepared to answer whatever questions because I know the details. I know my case, and I don't give a shit what comes at me, but I'm ready for this. And I want to do this now. That's the kind of feeling you need to have, because that's about 75% of making it happen. So what are some of the things that you need to know? Kind of like a checklist, so that you know that, oh, okay, yeah, I got that covered. And yeah, I got that covered. Yep, I can do that. Wait, no, I'm not sure about this one. Yeah, I'm going to make a note. So I'm going to give you some of these things to think about. So what I always did, for training purposes with my staff, was I broke down a case, and it doesn't matter if it's with the operations division, like your case manager, or whether it's at an appeal. I broke down a typical case into three categories as to what could go wrong with it. Okay? So one of them is medical. Every case, the first and foremost element that is considered in any situation, whether it's initial entitlement, whether it's entitlement to a particular type of treatment, whether it's how much return to work services you're going to be provided with, whether how cooperative you are, that medical is going to have an impact on just about everything that happens in your case. It's always going to go back to medical. The other thing is reporting inconsistencies. And so if you have an employer on a Form 7 writing down the history of a claim, and then on the Form 6, this is your report, and you write down similar, but you may have one or two inconsistencies, or your doctor on the Form 8. These consistencies can lead to problems. And those problems can then become bigger if you're not able to properly address those inconsistencies. And the biggest one is inconsistencies in medical. So in other words, you're appearing more disabled than what the medical supports. And I'm not saying that that's the case with you. I'm just saying how that inconsistency can become problematic. The third one is legislation. So at the beginning of the video, I planted a seed, and the one was to managing expectations. So I've had this discussion thousands of times over the years with clients. I get how easy it is for one to say, I'm so restricted with my back problem that I can't do a lot of the things that I used to, like play sports, work a second job, in my hobby, in woodworking, fishing. What I can tell you is that there is no section of the Workers' Compensation Act or the Workplace Safety and Insurance Act that will ever make up for those losses. Okay? It's not going to happen. And the sooner you understand that, the better. Because sometimes people are expecting things and a level of compensation that the law doesn't provide for. And I'm not saying that I lost my 2.5 fingers when I was a kid. Did I think 21% of the time was enough? Hell no. It robbed me of so many things. You know, my career in music, which was my passion. It changed the course of my life. But I had to adjust. And so managing expectations is important. I'll give you another example. And it's a very real thing that's happening right now, and I've dealt with it recently, which is you have an injury 5 years ago, and you return to work, and you had really high earnings, and then you have a recurrence, and you're now at the maximum allowed within the law, and so even though you're earning more now, you can't get compensated for it because it goes beyond what the maximum is under the law. So the point I'm trying to make is there are legal barriers to one's expectations that it's important to understand those right off the bat so you can close the door on it, move on and say, okay, that's not going to happen anymore. I'm not going to use it anymore as part of my argument because I know it's not going to happen. And it doesn't matter how many levels of appeals you go through, and it doesn't matter how many reconsiderations you have. If you continue to go down that road 20, 30 years from now, you're still going to be fighting an unwinnable battle. So that's why it's important for me to express to you right now, this isn't Joe Machado's law. Believe me, I would love it if we had a legislation that was more flexible, but it's not. But I'm doing you the biggest favor anyone could ever do, and that is to tell you that anything that you try to obtain that is outside of the legal construct, in other words, the Workplace Safety and Insurance Act or the Workers' Compensation Act, not only is fooling and kidding yourself because you're setting yourself up with these false expectations, but you're not able to move on and accept some of the things that are possible and perhaps argue those more effectively. I hope that makes sense. So let's talk about medical. Medical really comes into play in the majority of situations that occur. And one of them is that there is insufficient medical to support what you're claiming. So in other words, you have a lower back injury, and it's a strain, low back strain. Physiotherapy is recommended. There really isn't anything in terms of tests like a CT scan or an X-ray or an MRI that reveal something anatomically wrong with your back. So like a disc herniation, for example, or a prolapsed disc. There aren't neurological findings that are supportive of a degree of disability higher than a strain. And so you're the one that knows best, because you're the one that deals with your doctors, your GP, your specialist, your orthopedic specialist, your neurologist. If they're not giving you the support that in your mind would best represent your level of disability, then you need to make a decision as to whether or not you're ready for a hearing, or whether you're ever going to have that support. And no one knows better than you do. But I can tell you, if you're, for example, claiming that you're totally unable to work in any occupation, and the medical reporting doesn't support that, an appeals officer isn't going to be able to reverse the case manager's decision unless he or she has very concrete proof. And what that is, assessments, tests, provided by a specialist in the field of what your injury is, stating unequivocally the significant level of injury that you have. And unless that's there, an appeals officer he'll spend 5 minutes making that decision. You won't know that, because he'll give you your time at the table. He'll give you your day at the hearing, but he isn't going to be able to go against something that's not there, or fabricate something that's not there and be able to justify it in a decision, because when it comes time to paying benefits, that decision is going to get scrutinized by managers, directors, VPs at the operating level. Hang on, this guy's got a back strain and no other neurological or MRI, anything doesn't show anything significant, and the appeals officer is granting full benefits. They'll send it back. It won't happen. So, and the same with the tribunal. So that's one of the things about medical. So what do you do to get yourself ready? Well, you either accept that you're not as disabled as what you may think, and the tests, the results of the tests that are being conveyed to you by your physicians, or you can continue to try more treatment, and maybe another physician will make another referral to another specialist. And I've seen this happen thousands and thousands of times, but what happens in the process is now you get one decision or one specialist out of the blue saying, yeah, okay, and all of a sudden something new pops up. And the board is going to go, well, hang on. We've had all these doctors do tests after tests and it was never there, and how come it just showed up now? Is it a new thing that just happened? You see what I'm getting at? This is the biggest problem that people run into, is not managing expectations and accepting that at some point your physicians are telling you, and that could be a good thing, because that would mean that my son had surgery. He almost became paralyzed. He had a freak accident at home. He had 2 discs that just completely shattered. And I spoke with the surgeon before my son went in to have the surgery, and I wanted to puke. That's how sick I was in my stomach, because I looked at the MRIs and I'd seen thousands of these over the years, and I'm going, holy shit, I knew just how close that he could be from from losing his movement below the waist. It was the scariest thing that I ever went through that happened to me. Sometimes knowing a lot isn't good. This was one of those situations. I literally thought I was going to puke. And this is right before he went in for the surgery. And thank God. I mean, he has pain, he has bad days and good days, and it probably will be the same for the rest of his life, but he's gone on. He does all kinds of stuff. It's just shit that I look at him and go, oh shit, I don't know how he's doing it. He's young, but he just doesn't want to stay still, and he loves working in his carpentry shop. And anyway, I know all about how bad something can be, but if after you've gone through assessments and testing and all that, at some point you have to ask yourself, okay, is this it? And move past that. That's a question you need to ask yourself. And that's one of my examples when it comes to medical. Is the medical there to support your claim? Because if it's not, you're going to go to a hearing and you're going to waste your time there. And there's going to be more aggravation and frustration. And the same thing with the tribunal. And I don't want that happening to you. I really don't. Because I know how stressful and how defeating it is for that to happen. I just know that. Another medical situation is that the medical is not compatible with your injury or with what you're claiming. And again, that can fall under two categories. It can fall under the category that maybe the injury itself wasn't explained properly and there may be some discrepancies in the original reporting. Or it could be that you have another issue that's concurrent that happened totally without even your claim and has nothing to do with that, but could have happened at any point. And that becomes a diagnosis. And that diagnosis may become more under the spotlight than the actual effects from the accident. So when that's the case, you can't, an appeals officer can't, and nobody can, no lawyer or paralegal, they can't explain that away. The only ones that can explain that away are your doctors. And so the way to resolve that is a very detailed, like just sit down. I know sometimes doctors are in a hurry, they don't want to take the time to listen, but they have to. This is your life we're talking about. And make notes and say, okay, this is the injury, this is how it occurred, and they're saying that the medical that they're getting isn't compatible with it. Can you please help me and be more definitive as to why you believe this diagnosis or this condition that's happening right now is as a result of this injury. And it may even be that it's, a secondary condition that developed from the injury that a doctor could explain. But those are things that can only be explained and can be discussed between you and your doctor, so that when it's finished, good or bad, now you know, okay, yeah, I'm ready, but I'm not going to get that compatible situation because it's just not there. I can't get it. And then you have to move on. Another medical situation is no clear diagnosis. Sometimes it takes 2-3 months before a very clear, definitive diagnosis can be provided. And in the meantime, there's frustration, there's forcing you to go, maybe to go to treatment, and the treatment isn't working, it's making it more painful, and there's kind of this back and forth. And I know it's frustrating, but it's important to get at a clear diagnosis, because that diagnosis will be what everybody's going to refer to at a hearing, work transition services, approval for more treatment and medication. It's that diagnosis. To getting that diagnosis like established, clear, no ambiguity is important. It's crucial. And it can be frustrating if it takes a little bit longer, but it's worth it. And are you comfortable going to a hearing when you don't have a clear diagnosis? Because the appeals officer is going to ask you, this is what your doctors are saying, and it's not very clear. What do you think? And your opinion isn't going to mean anything because you're not a doctor. So the other one is the medical is influenced by a pre-existing condition. And I see this happening a lot. where you have an asymptomatic pre-existing condition. In other words, you have, let's say, a back condition that didn't bother you. Maybe something that happened when you're playing sports or when fishing or whatever. You tweaked your back, and it wasn't necessarily an injury. Didn't keep you from working. You didn't make any adjustments at work. So it really wasn't symptomatic, but then you have this injury, and after the injury, it becomes symptomatic. Well, yes, that happens all the time, and the WSIB can make decisions based on that. But when the condition, your injury condition, reaches a point where there really isn't much more treatment that's going to help, you kind of reach the plateau, and the WSIB is looking at having you assessed for a non-economic loss award. You know, if your pre-existing condition has become symptomatic and has continued beyond your accident condition, then it could be that the bigger problem preventing you from returning to work or engaging in work transition activities and that sort of thing could be, the biggest part could be your pre-existing condition. And I know that a lot of people won't like to hear this because they'll say, well, I had no issue with that before. That's correct. But it doesn't necessarily mean that it hasn't become symptomatic and that it could go on. And in fact, reach a point that it has become permanent itself. Well, then the WSIB can consider paying or incorporating that into the claim if that previously asymptomatic non-injury condition has become permanent as a result of your injury. It's a mouthful, but believe me, these medical inconsistencies can be a real problem. And if you have difficulty navigating through them, you're going to have trouble at a hearing. And there isn't an expert, lawyer or paralegal or anyone that's going to be able to paint through that unless they have definitive medical to be able to cover those inconsistencies. Another one is appealing the WSIB's denial of treatment that your doctor's recommending. And yes, there are all sorts of ways to address that, but that could be an issue going to a hearing. And so you need to ask yourself, why is the WSIB not agreeing to pay for this treatment? And is there anything I can do more than I already have, and any more than what my doctors have already provided, that I need this treatment? And if the answer is no, then okay, you're good to go. And rely on the medical, on what your doctors are saying. But that has to be definitive. Where your doctor is saying definitively that this treatment, I believe in my professional experience and my professional opinion, can help this person to deal with their workplace injury and the symptoms resulting from that. And then the other one is trying to get a secondary condition or getting entitlement for a secondary condition into a claim. And this happens a lot, especially when it comes to falling types of injuries, where you can have a secondary condition develop from that. And one thing about secondary conditions is that the etiology of that condition needs to be very, very clear. So your doctor needs to be able to support and state unequivocally that your shoulder problem is tied to your left lower leg amputation, and the fact that you required the use of crutches all the time and you ended up with a rotator cuff tear. I'm just giving you an example. That would be a secondary condition. So when trying to claim for a secondary condition, it's very important that the etiology of that condition be established, that the doctor has that very, very clear, and that there is a definitive, clear explanation as to why that secondary condition developed. Particularly if you're looking for entitlement, that the secondary condition is permanent, which then heightens the overall level of impairment through a non-economic loss reassessment for that condition and add it to your pre-existing or to your injury condition. That's where it makes a difference. So it's important to get that clear right from the beginning. So that's a question you need to ask yourself. If I'm objecting to a decision for a denial of a secondary condition, do I have all the I's dotted and the T's crossed, that I'm confident sitting at a hearing or a tribunal and be able to state unequivocally that that's what happened and that the medical is there to support it. Okay, so then I'm going to move to the next one. So there's three. So medical, the other one is inconsistencies in reporting, and I'm going to touch on the legislation. So inconsistency, and I'm taking a little bit longer with this video, but I don't want to cut you off halfway through, and this is too important to not cover the whole thing. So I hope you stick around. If not, you can watch it in two different segments, but I believe it's important that you know this. So most inconsistencies can take place right from the beginning. So there's three reporting mechanisms. The first one is you report to your employer. The employer is required to complete the report, file it with the WSIB, and give you a copy by law within 3 days. The next report is your report, Form 6. This is where you explain your injury. I can't overemphasize this enough. You have to be as detailed as possible about the mechanics of your injury, what you were working on at the time, how your injury took place, whether there were any safety measures in place, whether somebody else was helping you or not helping you, all of these things. I can't emphasize this enough. I've seen workers' reports of injuries over the 30 years and thousands of files I reviewed, and I'm going, holy shit, there's like half a dozen words there. I can't even understand it. People do that. They just expect that somebody sitting behind a desk reviewing that are going to assume what actually happened. This is one of those times where I'm a little, what's the word? Because I don't use it often, where I feel a little bad for case managers because they can only go based on the information that's in front of them. So be thorough, because once you get your Form 7 back, or after you've met with your doctor and explained everything and the doctor wrote it down and sent it into the WSIB, if you have to explain any discrepancies or try to clear up any discrepancies, it's your report that's going to be the most important. Because you're going to look at it and say, okay, well, the Form 7 doesn't state that, but I said that to my supervisor, and my doctor didn't state that. And I'm 100% sure that I explained it to my doctor or the person at the emergency room in the hospital, whatever the case may be. So you got to take the time and make sure that that Form 6 is clear. So if you have any inconsistencies in the reporting, and you're going to a hearing and you're objecting to denial of initial entitlement, you got to look at those forms and go, okay, or uh-oh, that's not there, right? You'll know whether you're ready for a hearing or not, or whether a little bit more work needs to be done, because those are the last two levels. You get two goes at it, and there's no more do-overs there. Inconsistency can also kind of deal with, whether the board deems that you're being uncooperative in your medical rehabilitation treatment or in your return to work efforts. I kind of consider that more under the medical, because it really is. But sometimes there's things in memos that you're not going to know about until you actually read the file, and somebody else has looked at it and made up their decision. And how are you going to refute it if you haven't actually looked at it yourself? But somebody can state, yeah, this job was provided, no problem. It was supposed to be 2 to 4 hours a day, and then increasing by 2 hours in the next week, and then increasing again. And in your mind, that wasn't there. That's not what was discussed. That could be a bit of an extreme situation, but it does kind of fall in both medical and in the discrepancies as far as, wait a minute, you're saying that I'm uncooperative? No. Because when they deem you uncooperative, all sorts of red flags go up. So those inconsistencies need to be cleared up so that you're confident that if you go to a hearing and you're asked questions by an appeals officer and your representative, you're going to be able to address those confidently without any issue. No, this is exactly what was stated. Okay? Now the last one. And I touched on this one a little bit. And that's legislation. It kind of falls in line with managing expectations. The Act is clear. The policies could be a little bit confusing because that's how the WSIB created policies and procedures to apply a particular section of the Act. And I always say, when it's not clear, always defer to the Act, what the Act states, the actual wording of the Act. Policies can be misinterpreted. The application of policies, it could be, well, it's this one and it shouldn't be that one. I've seen errors made both at adjudication or case manager level and appeals level, rarely at the tribunal. Rarely, actually maybe never. They're usually like right on the ball. So going back to my video, I think it was last Friday or Saturday or Friday or Thursday, the legislation, whether or not the legislation is being applied properly or the policies are being applied properly, the WSIB at every level, and I was talking about the reconsideration process. No, that was early last week. Anyway, you'll be able to go back to the videos. But anyway, they're required to specify what policy was applied in their decision and what section of the Act they relied on to make that decision. So if that policy in that section of the Act doesn't apply, it's very simple. The easy way to find that out is going online, entering the name of the policy that they're stating and the section of the Act and reading through it. Because it should read verbatim and it should meet the circumstances of the decision that they're denying. Basically, as I said before, managing expectations, there's limitations that are imposed by the law that you're never going to get covered. By the same token, it's their law and their policies, and they have to live by them as well and apply them consistently and without favor and in a fair manner and in a just manner. So if it is not within the policy, first of all, you got to compel them to provide the policy in the section of the Act. And that's when you can actually go and have it reconsidered. So if you watch my videos on reconsideration, the whole process is laid out for you. And we have those kits ready to go at WSIBsettlements.com. Which incidentally leads me to this. The topic was, how do you know if you're ready for an appeal? Even when everybody seems to be telling you that you are. So with WSIBsettlements.com, and I'm saying that because I developed that myself, we have a process where we can tell you whether, in our opinion, you're ready for a hearing, and provide a written report based on reviewing that, whether you're appealing a case manager's decision or whether you're going to an appeals hearing at the WSIB's appeals branch, or whether you're going to a tribunal decision or a hearing. We have a system in place that we can review that for you and give you our written recommendation, along with any of the applicable sections or policies and any decisions, any workplace safety and insurance appeals tribunals decisions that meet or are closely aligned with your case, so that you can go through them and feel confident that, okay, this makes sense or not. Okay. It's a very simple process. I'm going to put the link on the screen here, and they're just a questionnaire that you would fill out, and then one of our experts goes through it and provides a response, and it's done within 48 hours because we know how crucial and how timely it is to get this done, to make sure that you're ready to go one way or the other. There's a fee for it. It's all there, and it's peace of mind. And it's based on decades of experience. I find it's always good to have a fresh pair of eyes. There's many times where one of my paralegals would come into my office and say, I'm kind of stumped here on this one. What do you think? And I'd give them a fresh pair of eyes, and a couple of days later I'd say, this is what I'm thinking, and now it's up to you. Okay? So, well, friends, thank you for taking this time to listen. I know we've gone a little bit more than my normal time. I just want to make sure that I gave you a well-rounded information on this particular subject, because I know what it's important for you to feel confident as to whether you're going to do something or not. And nobody can tell you. You're the only one that can arrive at that conclusion. All I'm doing is giving you some things to think about to help you arrive at that decision. Okay? So if you haven't already done so, please subscribe to the channel. That's the way that I build the channel. It's free. Please share it with others. I'm sure there's lots of people probably in your circle of influence that you know that may be having a WSIB issue, and sharing one of my videos with them could be a bit of a lifeline. And give me a thumbs up if you like my content. If there's something else that you'd like me to talk about, by all means, send me a comment, and I'll work it into my videos. And if you have any questions about this content of today's video, just send me an email, and I'll reply with a response. All right, friends. As always, watch out for my shorts. There you're going to be able to learn what's coming up in the next day or two. And have an amazing evening. Take care, friends.